Good afternoon, everyone. I am really excited today to be talking about this incredibly important topic. I have two wonderful people to discuss this with, Justin Antonipillai and Josh Harris. Justin will introduce Josh and talk more about him in a second. I'd just like to briefly just talk about what we'll be talking about today, which is cross-border data transfer. There is a lot going on here. You all know that in Schrems 2, the Privacy Shield was struck down, and then other methods of transfer were put under a big cloud of uncertainty. And there have been kind of dark, nebulous clouds over cross-border data transfer for quite some time. And but recently, a lot has been going on. There was an announcement in March that a deal has been reached on a new Privacy Shield. It will still be called Privacy Shield, but there will be a new arrangement to try to deal with some of the problems in Schrems 2. And there are other things going on with regard to the cross-border data transfer for other countries as well. The CBPRs are now out of APEC and are now available to everyone. So we've got a lot of really interesting developments, and Josh will talk about some of these things. So let's get started and just really take stock of where we are and where we're going. So I'll turn it over to Justin to kick us off.
Yeah, first of all, Dan, it's great to see you. It's been a couple of months since we've been back together. And first of all, thanks for everybody who joins us today as part of a regular conversation that Dan and I host on a wide variety of data privacy topics. And over the last year or so, we've covered everything from AI and some of the cutting edge issues that are coming up around privacy and AI. And we've covered a number of different issues around cross-border data flows, upcoming issues around state law compliance. And Dan, it's great to see you as always. And today we have Josh Harris from Better Business Bureau National Programs. And Josh, you've been a leader in the field for years. We're going to give you a chance to talk a little bit about your background before you came to BBB. And BBB, National Programs, plays a critical role in a number of the cross-border data programs in terms of accountability. And so you all have seen on the front lines some of the opportunities and challenges that come out of this area. So it's great to have you here today. I will say, Dan and I always start these discussions on cross-border data flows and the opportunities around enabling movement of data from country to country when it comes to personal information, Josh. And the fact that when it comes to that movement, there's an increasing set of privacy protections that are now going with the data. In my view, this is a great thing. And Privacy Shield ends up being one of those great data transfer frameworks. We've had multiple sessions, Dan and I, around that alone. But it's exciting to see what the Department of Commerce has been leading with their new framework that includes Canada, Japan, Korea, Philippines, Singapore, Chinese Taipei. You sort of see these cross-border frameworks growing. I tend to be an optimist in this area. There's certainly a lot of worries too, but some phenomenal developments that we can cover today. So it's great to have you here, Josh. If you don't mind, I'll turn it over to you for a moment. Give us a little bit of your background, you've been in the space long enough that it might be helpful for our viewers here to just hear from you of how you got into the space, and tell us a little bit about what you've been doing at Better Business Bureau National Programs.
Sure. Well, Dan, Justin, thank you so much for having me today. I really appreciate it. My name is Josh Harris. I'm the Director of Global Privacy Initiatives at BBB National Programs. And as Justin mentioned, one of the things that we do here is to provide a lot of the operational support to implement these frameworks. So we do dispute resolution for Privacy Shield. We're what's called an accountability agent for the CBPR and PRP systems. We'll talk a little bit more about the developments around those. So we're very much at the front lines. And what we do is to work directly with the companies as they try to get themselves into these frameworks to be formally recognized so that they can get those benefits that are attendant to them. And Justin, that's where I'm optimistic as well, because there are a lot of benefits that are afforded to the businesses that are participants in these frameworks. And what we're seeing now is the operationalization of them, which is so critically important. It's one thing to have a set of principles or guidance. It's quite another to have an operational system in place. And of course, there's a whole lot of work around that. And to see Commerce's leadership in that starting to really take off has been very heartening for me. I come from Commerce. I originally started my career there, probably 2006, maybe, in what was the previous office to what now administers Privacy Shield and the CBPRs. Back then, it was there were no CBPRs, and it was Safe Harbor. And spent about 8 years there, and then moved over to Future Privacy Forum, to TrustArc, and now to BBB National Program. So I've really been working on these cross-border issues, both in the policy realm, but then also in the operational realm as an accountability agent or a dispute resolution provider for a lot of them.
Well, listen, that's fantastic. And, we at Wirewheel, our team here, partners obviously with BBB National Programs on that. We're proud to do it. And you all have really established a fantastic set of accountability programs at BBB, Josh. So thank you for that.
And thank you for the support for the Wirewheel platform that allows the businesses to actually get online and use them. That is actually what allows this thing to scale. And scalability, as we'll talk about a little bit later on, is key to the success of these things.
Well, that's fantastic. Well, Dan, why don't I turn it over to you for the first question, and then we can start our conversation around this important topic.
Yeah, so I guess I think it'd be interesting to kind of shift back and forth between these things, but I want to go to the EU, where we're kind of just coming out of this uncertainty period of what do we do in the wake of Schrems 2, and it looks like we have this agreement. From what I hear, it's still going to be called Privacy Shield, and a lot of the so-called fixes, the repairs to Privacy Shield, will be in the form of mechanisms to address a big concern that the Schrems 2 court had, which is ability of people in the EU to challenge government surveillance, government access to their data. And that's something that companies can't do. It's really up to the government to address that concern. So it seems that what companies were doing under Privacy Shield will return, and I don't think companies will need to do much more, from what I understand. But the real answer is going to be the U.S. government's going to start doing something differently. And I'm wondering what you've heard about this, what your thoughts are on, is this going to work? And will this fly? It looks like there's an agreement, but I guess ultimately we've got to get something that will stand the test of the ECJ. Schrems is certainly going to bring Schrems 3. So we're going to at least get a trilogy. What's going to what do you know, and kind of what do you think about where we stand on the EU?
Is this one me or you, Justin?
Well, I think, why don't we start with you, Josh? I have some background on this too, but I'd be happy to have you jump in first.
Sure. I mean, look, as far as I understand, I hear that the commercial protections are going to remain the same as they are under Privacy Shield. And what we do is, obviously, as I mentioned, we work with the businesses directly. So this is where we're spending a lot of our time, is to make sure that the transition to the new Privacy Shield is seamless for the folks that have left and want to get back in. As far as the redress mechanisms that are being established, as I understand it, this is all pursuant to an executive order. And the executive order, to my knowledge, has not yet been released. And I would ask both of you, is it within the contours of this EO that we're going to find all of the kind of fodder that's necessary to kind of stand up the new TADF? Is that a correct understanding?
Yeah, if I may, there's a couple of things that I also understand, although I did confirm a fair amount of this, even when we've had sessions with the European Commission and with the folks from the US in the last couple of months. First of all, the framework that was announced by both the European Commission and by the White House, they're still going through the final documentation and the legal documentation in the legal text, but obviously there have been extensive exchanges of text at this point, so I don't expect it'll take much longer. Critically, there are no changes whatsoever to any commercial requirements. So if you certified under Privacy Shield, while you may not have had any benefits from certifying, if you continue to be certified, once Privacy Shield is, or the new framework as it's called, is approved and it's an adequate means of transfer, you will pop back in and be able to use it without any other changes to your program. And that's terrific news for all of the companies that have kept up and maintained their commitment to those critical requirements. Second, it was very important that the two sides clarified that no statutes have to be changed or adopted to adopt the redress mechanisms. It's important not only because you want to be able to actually see it across the line this time, but as both you, Josh, and Dan know, it's proven to be very, very difficult to pass any legislation relating to privacy. So if one had adopted a number of statutes in this way, and then you would have had to modify them or update them or change them, you would have been in a very inflexible place in terms of updating different issues in the future. So the fact that they've supplemented the redress mechanisms in this fashion in a way that can be accomplished, that materially improves the redress mechanisms, but that is established without a statute, is huge in terms of the flexibility of the program. So agree with you on all of the above, Josh and Dan. It looks like there'll be the normal process next of releasing the text and then going through the trilogue, just like you did with other transfer mechanisms, to get an adequacy finding. And so there'll be some trailing window of time after the release of the text. But I think the expectation is it'll be adopted and then go from there.
Yeah, I've been I'm a little skeptical about, whether they can pull it off. I think it seems to me, somewhat optimistic that, whatever mechanism they can get through an executive order is really going to fully address the issues. And in particular, I guess what I think about is this, is there a meaningful ability for a person in the EU to challenge the surveillance? Because a lot of the surveillance and data gathering occur in secret. And so if you don't know that data is being gathered about you, how can you challenge it? So are we going to get a challenge right that's totally meaningless because people don't even know that the data is being gathered? Now, the government doesn't want to tell people where are they gathering data from and how are they doing it, and because then it tips off the people they're trying to surveil. And I just find it hard to imagine that they would have the kind of transparency about the data that would then create a meaningful redress for EU folks to challenge. The other irony would be, that if you do get that kind of transparency and you get this ability to challenge, U.S. citizens now actually take a back seat to the EU, people in the EU. So, as a U.S. citizen, I barely have much ability to challenge it because the Clapper case denies standing unless I know that I'm under surveillance and the government won't tell people that they are. So then they don't know. And then the court says, well, you can't manufacture standing. It's all speculation because the other side won't tell you whether or not you're being surveilled. So you're in this weird limbo where you think you're being under surveillance. You think your information's being gathered, but you can't really challenge it. But if someone in the EU then could, that's weird. That the EU folks kind of get rights that U.S. citizens can't exercise. And then the irony too is, well, okay, then I'll just, if I want my rights, I'll travel to the EU, I'll be a person in the EU, and then that's how I can challenge U.S. surveillance. And I just wonder, how is this really going to work? And it sounds nice, but I'm just color me a little skeptical. I just don't know if it's going to fly or not. Another thing we don't know. Yeah,
I think those are totally fair. I think just to make sure we're on the same page, and Josh, then we'll turn it over to you. Okay. First of all, the test that we're all under is essential equivalence to Europe. It's not something else. So in Europe, Dan, an individual can't just go discover what's being conducted and collected by the intelligence agencies. So because it's kind of the way that works. If everybody knew what was being collected and for what purpose, it might compromise the programs. I'm not an advocate for any of this. I'm just saying the test is not that that the United States has to meet some abstract rule. It's just, it has to be essentially equivalent, not identical to what the basic framework is in Europe.
But I would take issue with that a little bit because, the GDPR doesn't restrict or really address government surveillance at all in the EU. It's always been a standard that is not the same. Other countries are held to a much higher standard by the ECJ on their surveillance laws than the EU. Despite the essential equivalence, I don't think in practice that means what it says.
Well, look, I agree with you that one can always be skeptical about the actual application. I'm never Pollyannish about it. I just think it's helpful to frame it. The actual legal standard applied on its face is essential equivalence. And that means you're comparing one regime to another. Second, when you're looking at Schrems, the real focus was on independence of the reviewing board, as an example, okay? And there was fundamental worries about that fact. You have to be collaborative in these kinds of engagements. By the way, I'm not here to defend anything. I haven't even seen it. All I have at the moment is the fact sheet as it was laid out by the White House and the fact sheet as it was laid out by the European Commission. And when you look at it, they've added what's described as a multi-layer redress mechanism that includes an independent data review court that would consist of folks from outside the government with authority to adjudicate the claims. Now, Dan, you and I are both lawyers, and I know everybody listening to that who is practiced in the US, it's pretty tough in a very important but technical sense to create an independent judicial body by executive order. So there is a technical set of challenges there that will be the basis of any claim, no matter what you do. So if you don't have it by a constitutional creation and you don't have it by a statute, it's pretty difficult for an executive to create an independent thing for obvious reasons. Otherwise, you would have the executive creating independent parts of our government, and that might be problematic. So I think the reason I just wanted to make sure I fixed this here is there is some very important indicia of independence that the teams on both sides of the Atlantic have really built into this. If you look at it, people outside the government, independent authority, ability to adjudicate the claims, these are all things that Schrems 2 had asked for. I think it'll be one of those things that people have to review and understand the text to make sure it actually meets the requirements of Schrems 2. And no matter what, even if it was like a completely new Supreme Court of the US for data transfers, you still were going to have a challenge. So the fact that somebody's challenging it doesn't necessarily mean it's flawed. It just means it's going to be challenged. And I think until we see all of the details of what it is and exactly how they create it, I think we're all right to be skeptical, Dan, to be honest. But with that framing, I didn't want to jump in here. Maybe, Josh, I could turn it over to you to your reactions to what Dan covered.
Yeah, I mean, I agree. There's obviously room for a healthy dose of skepticism, and everybody expects that there's going to be that third challenge. One of the things that, we are constantly on the lookout from the operations perspective is, okay, well, when will this actually be formally executed? And I wonder, I guess, just everybody, and Justin, in your past experience in Privacy Shield 1, when you get to the agreement in principle, and then you kick it over to the process that you had mentioned before, where we're looking at, first the EC draft recommendation, and then there's the consultation period and all of that. What do you guys think? 6 months? I mean, as the end of the year? I've heard that kind of bandied around a little bit. Could that be a date when you would actually see, okay, here we are, new Privacy Shield?
Well, I mean, first of all, Josh, you're right. It's going to take some time. My experience has been that the European Commission ends up collaborating very closely with the other branches that will review the adequacy finding before the text is sort of publicly released. I don't think it's going to be a surprise to the data protection authorities. I don't think it's going to be a surprise to the relevant bodies in the European Parliament. So I think there will be a fair amount of understanding of what this is before it's released from the European side. I know Dan knows that on the American side, they've had a really fantastic interagency group, led obviously by the Commerce Department and Chris Hoff, but with a lot of other teams like the intelligence community, DNI, Justice Department, the White House. So I think there's going to be a pretty broad set of actors read in on this, and I know that a typical process would be that the Commerce Department would also brief the relevant congressional agencies or not agencies, but congressional panels and committees to make sure they're aware of it as well. So there's definitely going to be some time and some process to make sure you formally release it and the public gets to understand it. But the fact that there will have been so much internal consultation should make the process at least move reasonably quickly. And I think the rough window of between 3 to 6 months of getting the final adequacy finding, I think, is a reasonable window to imagine once the text comes out. Dan, do you have any perspective on that?
Not too much. I mean, I think it's just going to take some time. But once it's kind of back, if it's the case that everyone who was already had Privacy Shield in place suddenly gets their shield back, that will also speed things up, because the original when we shifted from, I believe, Safe Harbor to Shield, the process had to start all over again. But now it seems that, from what I hear now in this conversation, that the information you have is that you'll be able to just pick up right where you left off. So that's going to speed things up a little bit. And I really don't know too much on time frame. It's not going to be immediate. It's going to be some time to get this all worked out. I still think there's another cloud, some storm clouds in the distant future, which is that the ECJ really has only looked at this issue for adequacy about the government surveillance, government data access point of view. It's never really looked substantively at, does Privacy Shield really come close enough to the GDPR? Now, I'm not sure it does. Everyone's seemingly okay with it as a compromise. But it's not, the ECJ is not a kind of a compromising court from what I've seen it do so far. I wonder at some point, will that issue be ever looked at? Once the government surveillance piece is dealt with, is that the end of the issue, or are there some substantive differences that really matter between the GDPR and other legal regimes? So far, when I look at the adequacy decisions that have come out, I would say that pretty much, the closeness to the GDPR really does not matter at all. Because when I look at some of the laws that, are found adequate, they're not close to the GDPR. I don't think Privacy Shield is really close to the GDPR. It's basically the US approach with, not much more to it. So at some point, maybe someone will look at that and say, hey, maybe adequacy should have some kind of principled basis behind it. Because right now I look at it, I find it completely unprincipled. The decisions really, there's no rhyme or reason to any of it. And it's just a vehicle for kind of pushing this government surveillance thing. The ECJ is trying to kind of create some kind of principles, although it's a weird set of principles because it's something that, companies can't control. It's a very difficult, issue to hammer out. But so I think it's still a bit of a mess and not very coherent when I look at it. That's my thought. I'm curious what reactions are, and then I do want to, also get into, the other regimes outside the EU.
Yeah, I mean, you and I at some point, Dan, just ought to debate this because it's be kind of fun. I don't know whether I want to take your position or the one I typically take in these, because I'm almost always on a counterpoint, even though I think there's a lot of nuance to this. If I were to be put in the devil's advocate position without really, believing everything here, another way to look at it is, you're looking at essential equivalence. So the principles that are adopted in Privacy Shield, but also in the laws in Japan and Israel that have been found to be adequate, they mimic and sort of roughly track the fundamental principles. And that's the most important thing. I think one could say that Privacy Shield has been operating now for several years. When I've seen the reports, and Josh, you may have a better sense of this, and maybe I will turn this over to you momentarily, like where do we see, without any specific mentions, where do you see the kind of issues coming up and accountability problems? Like where do you see the complaints? Because mostly what I've seen when it comes to Privacy Shield, you've seen some companies who've let their, certification lapse and then they still certify, or some companies claiming they're Privacy Shield certified when they're not. I haven't seen a ton of complaints from a company from sort of a data subject perspective where somebody's saying, I was supposed to get this right and I didn't, or there's a problem. And I would be really interested to hear whether that's so, because that would mean something. So Josh, maybe I could turn it over to you, on that. Or what are we seeing in terms of issues under any of these data transfer, kind of agreements?
Always access. Always, always, always access, because that's the tip of the spear. That's where the consumer interacts with the framework. You're seldom going to find something, for example, around accountability or security safeguards, where the consumer says, I have a sneaking suspicion that the security protocols of XYZ company do not meet the reasonability requirements under Privacy Shield, so I'm going to lodge a complaint. It's usually, I can't get into my account, I can't unsubscribe. These are kind of like the basic balls and strikes of this is your interaction with a Privacy Shield or CBPR certified company. And so generally, to the extent that they come in and there needs to be a remediation, it has to do with those very specific provisions that the consumer is allotted as a right pursuant to that company's participation in the system. And that bears out when you look at the annual reports for Privacy Shield, for CBPRs across the different dispute resolution providers, you see the exact same things. So you could really probably draw a very clear and replicable trend line, regardless of the year and regardless of the provider, seeing the same sorts of issues. And that's what that frontline DR catches.
Yeah, I think, Justin, I think we should have this debate because I think we're talking about slightly different things. I mean, there's kind of what companies can do to comply. And I think, companies are trying to do what they need to do to comply. And when we look at the enforcement, a lot of it is just kind of nipping around the edges. But, it's very similar. Really, I mean, the Shield basically, the FTC already regulates a lot of the companies in Privacy Shield. It's basically notice and choice. It's the essential backbone of the U.S. approach, which is, very different than the GDPR's approach in many ways. Different view of consent. I wonder, what parts of the GDPR are sacred? If is Israel okay? Japan is okay, and Japan is, I think, closer to the U.S. than the EU. You have very weak enforcement in the New Zealand law. Canada's enforcement is pretty weak. Just a bunch of principles. So why don't we just enact 10 hollow principles that just like, please do this. We hope you do it. Be nice. Which is kind of the Canadian approach. And I guess in Canada, you tell people to be nice, they're nice. But that's not how people aren't nice in the U.S. But I mean,
what's interesting? First of all, I'm up for it. I accept your challenge. I think we had to do it whenever, and we had to put somebody in charge of giving us a lot of time, Dan, because I think it'd be fun.
Yeah.
But to me, if I may, in the U.S., one of the most important things that could happen here, and I'm really interested in how Ashkan Soltani and the California regulators look at this, is California actually contains the first U.S. requirement that you actually file a privacy impact assessment with the state. Now, the three of us know, because we've been around for a while, that if you make the CEO of a company or somebody senior sign a document and file it with the state regulator under oath, it becomes a very big deal in the US. You want to talk about something where you have some teeth to it, you turn to the CEO of a company and you say, you have to sign a document that says you're doing with your data what you said you were going to do, and you have to do it under oath. You're going to see enforcement and accountability increase by tenfold. Now, exactly how they're going to enforce that mechanism and what you have to do, I know California is still defining, but it's a really, really important thing because you don't have to file or certify. And the reason I say this is, Dan, I don't mean to be pointing, by the way. I think we all know that Sarbanes-Oxley actually had an enormous impact. It's not just wave the hands in terms of making sure your financial statements have some real reliability to it. And we all know that one of the reasons they got there is because CEOs had to put their signature on a piece of paper saying it is as we say it is. So I think that is probably one of the most interesting opportunities in terms of true making something change, because the law doesn't say that you just create a data privacy assessment. It says you have to file it. And companies take that kind of an obligation seriously. Anyway, but I don't want to distract. We definitely have gone, as Dan predicted, over nearly 40 minutes, and we haven't even touched another important subject, which is the new global cross-border privacy rules, the CBDR Forum. We haven't talked about the new efforts from the OECD, which could be really interesting in terms of building some more sort of accountability and real global cross-border data initiatives. Do you mind if I turn it over, Dan, to Josh here for a minute to talk about those two, because they're really, really important efforts in my view.
Yeah, this is kind of breaking new ground. The Global CBDR Forum, for those of you that are not aware, it is the APAC cross-border privacy rules system developed in APAC, 21 member economies, and has recently been moved out of APAC into an independent forum. And the membership consists of the current participants, the current economies that have joined that CBPR system. But it's now open to countries outside of APEC. So they just had their first meeting of this global forum in Hawaii 2 weeks ago. I was fortunate enough to be able to attend. And they had, I think, 15 different jurisdictions that were participating in that, including the UK, Brazil, Colombia, Chile, Dubai, Bermuda. I'm going to be forgetting names, as well as the countries that are already members of the CBPR system. And the idea is, okay, within the structure of this new forum, consensus-based, first of all, they can bring in new members. Second of all, they can update the program requirements. And the idea there, under the CBPR system, the approach is essentially where you find commonality, common elements of requirements under law, they're commonly enforceable. That becomes a candidate for a program requirement to be something that you're certified against. The key is that every jurisdiction has the ability to enforce that same program requirement, but there isn't a judgment as to the way in which it enforces it. So you can use Section 5 for basically any consumer privacy protection that would find its way into a certification system over here, whatever it might be under PIPEDA, whatever it might be under UK GDPR if they were to join the system. So there's a lot of interesting opportunity here to kind of build up a new framework, a new structure, a new forum, consensus-based with like-minded countries to be able to continue, first of all, the adoption of the CBPR system, but also the operationalization of the system, which becomes really important when we're talking about its ability to be able to gain traction in different jurisdictions. You want companies to follow these regulations or these obligations the same, regardless of the jurisdiction. We want their certification to be the same, regardless of the jurisdiction. That's what makes the whole thing work. That it's recognized, for example, under Japanese APPI privacy law. It's one of the bases for transfer, whether you're a CBPR certified company in Japan or you're a recipient outside of Japan. Recognized both ways. It's recognized under Singapore law. It's recognized in the USMCA. So you're beginning to see its recognition in these different legal instruments. I think what's left to do is to be able to get the critical mass of jurisdictions together, to be able to come together and say, this is what it means to me. It's going to be different in each jurisdiction. In the United States, it's still a best practice. Justin, when you were talking about Congress or the congressional committees getting a readout about Privacy Shield, I was thinking, how valuable that is, because when we've looked at the different data privacy bills that have come out of the Commerce Committee, you don't see anything that actually has any recognition of the international instruments that might be at play here. So you don't hear about things like Privacy Shield or CBPRs in them. Although it's certification and codes of conduct that are the primary basis for the negotiations that our USTR and our Commerce Department friends use to be able to maintain the free flow of data. So it would be really nice to see those instruments actually find their way into a positive US law.
By the way, Josh, just one thing on that point that I always found interesting, and I don't know, Dan, if you or Josh ever thought on this, but the US tends to take such a different perspective on cross-border data flows, even when they're thinking about a global, sort of a national law. Mm-hmm. In every other national regime, when there's a national law, there's the concept of if then data passes from our borders somewhere else, right, you have to do something about that, or you need a means of transfer. That concept has actually typically not been part of the draft US laws in many ways, and at least not in the same way that you have under other international laws. So that's part of the reason that the international data transfer issue tends to be only from the, say EU to US data transfer side. And obviously, because there's only state laws right now, no state really can be in a position of regulating data transfers to Europe. That would be a big kind of problem for many reasons that Dan could probably teach a course on. So you have a lot of tension here in the way that it's being regulated on a state by state basis. Mm-hmm. When you get to the point that onward transfers is a very important concept under most data protection laws, and it's not really being captured from the US out right now. Right. Anyway, I didn't mean to interrupt, but
that is why you don't see consideration of that in the laws, but more importantly, you don't see consideration of the instruments around that in the laws. And so that leaves a lot on the table, especially for our negotiators that are cutting these kind of deals. I mean, imagine if they did have the authority, for example, under a bill that, let's say the Wicker bill, I think, had in it recognition of certifications or codes of conduct presented to the FTC for approval that would meet all or part of the law. Now, I think that would change in a real way the dynamic of the negotiations. Because there would then be a way to be able to kind of create, and not just with the EU, but there is a way to be able to create that kind of a back and forth in a negotiation with another jurisdiction when you're saying, well, hey, we would like for you to recognize this certification standard. Okay, what's in it for me? Well, nothing.
Yeah, listen, that's a phenomenal set of questions. And I don't know if you've seen, but we've, just because we're going to run short on time here.
I know, I am, yeah.
There's a number of important comments and questions that have come up from the many viewers. Do you mind if I run through a couple for us just briefly to cover here? One question that came up is Shrem's, obviously a lot of great friends I see here for all of us who are participating and throwing in questions here. But one question. What about Shrem's threat to take any new privacy shield directly to the High Court for a very short review, weeks rather than years? Josh, Dan, do you have a reaction to that?
I mean, we'll see. I mean, I think Shrem's is obviously very committed to, not letting up the pressure. I don't know enough about the EU system to know, how likely he is to be successful in getting this kind of expedited process. But if he is, I'm sure he's going to keep challenging it. I really can't speak to, how readily or feasible, his prediction that he can do this that quickly will be.
Yeah, I have the same perspective. I think I'm quite confident there will be an attempt to have an expedited review. This is one where typically you have a filing, and typically it goes back through to the kind of the country courts before it's referred over. I know there's a mechanism for it. I remember seeing this years ago. I wouldn't be in a position to say whether it has a likelihood of success on an expedited review or not. There's another question that came up. Let's see. Don't the proposed changes also contemplate a review of a court who will act on behalf of an EU data subject to ensure that the rights are not violated by a government surveillance activity? I've seen a mention of this. I think I can speak to it a bit, but Josh or Dan, do you want to cover this?
You can go ahead.
No, you go ahead, Dan. That's you.
I would only say I have seen notions of this. I've also heard it discussed a bit. I haven't seen the text. I do think if they did include something like this, it would help having somebody who can actually speak for the EU data subject in these proceedings, because you're not going to have EU data subjects coming obviously to an EU tribunal to make this case. So I think that would be a really important thing to make sure you're representing the data subjects, but I haven't seen enough details on it to know whether it's going to work. There was a question on impacts on SCCs. We haven't talked about that. Dan, Josh, what's your reaction there?
I mean, would it look similar to the impact on SCCs when the first Privacy Shield got, well, not invalidated, but when it first came back online after Safe Harbor? I mean, I don't know if you guys have any experience in the numbers that people that were absolutely using SCCs versus Privacy Shield and the relative appeal of that when that came back online. I don't know if that would look similar now, or, Dan, to the idea that there could be a very quick review and a very quick invalidation, whether or not a similar sort of shift or migration would happen.
Yeah, I mean, I think that, Shrem's affected SCCs. A lot of this was kind of navigated around by companies saying, well, we don't think that our data is likely to be looked at or accessed by the government, and you do these, transfer assessments. I guess when I look, and this goes to my heart of my debate with Justin, I'm not really, I have mixed feelings about this whole endeavor. I mean, part of it is the professor in me sees this as being unprincipled. I don't see principles here. I just see a lot of just political maneuvering, which is actually, I think, very beneficial to the EU. They've gotten a lot of traction by doing this and by requiring this. So I think, like, politically, it's a win, but it's incredibly conceptually messy to me, and it drives me crazy when I'm trying to figure out, okay, what does this actually mean? Is there a principled approach to data transfer across border? Now, you were mentioning earlier, Justin, that the state laws, don't address this. They actually do a little bit, because some of them do require data transfer agreements for all transfers to, third parties. It could very well be, there could be, a requirement in laws. I don't see why not. Laws could say any transfer, including a transfer from a company internally, could be governed by some type of principles, or transfer to a third party, regardless of what country they're in, should be governed by some set of principles, by an agreement of some sort. The problem with the cross-border data transfer, as I see it, is I don't see principles here. I just, when I look at the decisions, and I just see chaos. And it'd be nice to actually figure out, okay, what exactly is going on here? What are the actual goals? Like, what are we trying to achieve? Because what's going on is this kind of like this weird shell game, or this guessing game, or these attempts to do this that I'm not sure are like what they're actually substantively achieving. So, I mean, it's a tricky game for companies to figure out, how do we comply, and what, are we getting hotter, warmer, colder, which is this weird game. It's almost like that game you play as kids, like getting warmer, hotter, no, colder. So I would love to see an actual principled framework with clear goals and a clear set of rules that would give this coherence and actually make it somewhat meaningful, rather than more of like what it is now, which is kind of like a political cudgel, is what it is. Just a political tool to kind of, put some pressure on, other countries in some ways, and make companies sweat. And that's how I see it. I'm not saying it's necessarily inherently bad to have cross-border data transfer requirements, but it'd be nice to have something that's really, principled and coherent. And I don't see that thus far, but maybe there is a coherent approach that someone could articulate for me.
Well, I'll tell you what, when we debate, I'm ready to go. I'll have to prepare a little bit to be ready for you, Dan, but I'll give it a shot. Okay. But I'm going to add two things here just in the last few minutes, if you don't mind. One is on the specific questions of SCCs. So when there's a new adequacy decision, in my view, you do not need to do data transfer impact assessments, which I know, Dan, is not an academic sort of subject that comes up, but the pain points for companies doing these data transfer impact assessments when data is moving to the US is, it would make somebody crazy if you see what's going on. Once you have adequacy in the US and the system's declared to be adequate, you shouldn't have to do that. I'm not saying that companies aren't going to ask for them. I'm not saying that still, as a matter of commercial requirements, they still may not occur, but there's no principled basis really in the law to require a data transfer impact assessment when data is moving from Europe to the US once you have an adequacy finding, because it's the same fundamental set of questions. And those were really caused by Schrems 2, which was focused on saying that it was not adequate because of these redress issues. That may not be permanent, there's other things to it, but I think that'll be the biggest effect on SCCs right now. And let me come back to it. Where I'll give you my perspective, and maybe we could each do a few moments of wrap up. I too, and I will articulate, when we get a chance, Dan, I have some real worries about the way these global laws are applied, what's meaningful and what's not, and where you could actually make a difference on changing things for human beings, to be honest. I'll give you a good example. A critical thing that is a problem right now is that the right to deletion is basically implemented as an all or nothing problem or solution. And that makes no sense. And if you think about it, if you go back to the days when you started being able to move your phone from one provider to a next, you always got to keep your phone number. That's when it became meaningful. If you told somebody, I have to cancel my account and I lose my phone number, people don't move from their cell phone provider, right? Because your cell phone matters to you. You've had it for years. People have it everywhere. If I go to a major platform and the only way to get rid of my data is to delete my handle on a major platform or on one of these things, and you lose your identity, which you've built up over years, that is not a meaningful exercise of the right, period, full stop. You should be able to delete and have deleted the history if you want it. You should be able to delete in a much more granular way. That would make a difference to a lot of human beings, and it would actually start to make the right of deletion meaningful for people all over the place. But if the only way to do it, which is true on most platforms, is to say, I'm deleting my profile, it really disincentivizes you to do it, and it makes it a non-meaningful right. So I do think we should talk about what's meaningful for human beings and ways that you could implement these in a much more meaningful way. And we should put that on the table, Dan, when we talk. But I'm not, as a general matter, as negative on the way that cross-border data flows are actually developing. I think there have been some countries and parts of the world that have taken a leadership position and have actually set some basic ground rules. I think they're building on some fundamental principles that were born in the United States and the federal information privacy practices. So I do think there's some consensus developing on the fundamental principles. I think the way they're enforced and the way they're spreading, I think, is a little ad hoc for me. And you do need some lean in from things like the Commerce Department to actually take a leadership position. But I do think you're going to end up with a lot more progress this way than if we did nothing. And I think the likelihood of like a global treaty that would actually do this across all borders, I think that's really going to be hard to get to, which is part of the reason that you end up with a much more ad hoc approach. And those are my quick observations, if you don't mind. And maybe I'll turn it over to you, Josh, next, and Dan, you'll get the last word before we go.
Yeah, I mean, I agree that there needs to be some sort of a systematized and ideally global approach to this. We talk a lot about, for example, the difficulties in managing the adequacy process, but to date, the adequacy process has been a one-way street because one law is operationalizing it. But as you see the proliferation of laws that have adequacy recognitions in them, imagine what would happen if you had a dozen or so jurisdictions that were doing concurrent adequacy determinations. These adequacy determinations started to pile up on top of each other. I mean, to give you just an example, Japan has been deemed adequate by the European Commission. Japan, under its privacy law, has the ability to recognize as adequate other jurisdictions. Within that adequacy determination for Japan, there is this little footnote that says that the EC will review any adequacy determinations that Japan makes about other jurisdictions. Now, this could have become a live problem, for example, when the EC was negotiating with Korea. What if Japan jumped out in front and said, we find you adequate? And the EC says, oh, no, we haven't found you adequate yet. This can become a very thorny problem. One of the things that I think helps to solve this is the multilateral approach. Right now, this APAC new global privacy forum is a regional approach. Hopefully it becomes a little bit larger in scale, but it provides an alternative. It's not a replacement of adequacy, or it's not any kind of a way of pushing a rival to the adequacy model. But I think it's very necessary to be able to have another tool in the toolbox for companies and jurisdictions alike to be able to work together. Because simply relying on adequacy alone presents a whole host of problems, not the least of which that there are not that many jurisdictions that are found adequate. But probably also in the future, even if it was to be a successful uptake, you would have multiplicities of adequacy, which would become even more complicating. So as much of a challenge as it is to try to create a global solution or a global treaty, of course, I know that that is a very far-fetched idea these days. Creating these sort of cooperative mechanisms is imperative because there really is no other approach.
All right, Dan. I agree with you, Josh. And Dan, you get to read us out in the last minute or so.
Sure. Well, this has been a really interesting discussion. I think we could go a lot longer. A lot of my objection is not necessarily to the idea that there be cross-border data transfer. I actually think that the requirement has been generally a good thing and has helped privacy law develop in some good ways. I guess that it's a little too much of like watching the sausage being made for me, and I'd like to see, it'd be nice to see a little bit more principle behind, especially out of the EU, like what exactly are they looking for? Like what are the key principles here? Is it just government access? Is it something else? And let's make this more meaningful so that it be more clear. Okay, what is the actual standard here? Because we really don't. I think we have a goal, like let's do something. Let's try to ratchet up other countries' privacy laws, but it's not clear what the standard is, and that's I think where we're getting all this back and forth with the ECJ. What exactly is the standard? And then you have these requirements that I think are. I agree with you, Justin. Doing these impact assessments is ridiculous, really. How is a company supposed to figure out, the lay of the surveillance law of all these different countries they're transferring data to, and suddenly become an expert in all these laws? And then there's the laws as written, but then there's all these practices that are going on behind the scenes. So you really can't get a very good picture, I think. And these transfer impact assessments are a lot of theater, in my view, and asking companies to do almost the impossible. So it's a big burden, and I think it's due to the fact that it's just not clear like what we're aiming for here, and what the goals are. But that said, I think it's a good process. I think obviously as the world struggles to come up with a consensus and builds privacy law, that the process is going to look rather ugly and messy in this way. And here we're in the thick of it. It does look like we're making progress. The CBDR will bring this to, I think, more in the U.S. and address transfers not just to the EU but to other countries, which I think would be good. So I have some optimism, but also a little bit of frustration at the kind of lack of a kind of real coherent framework for all this. Thank you both for joining in this conversation today, and I'm sure we'll touch on this issue many, many times throughout the year as this unfolds. So thank you very much, and thank you all for joining us.
Thanks, Josh. Good to see you, Dan.
Yeah, thank you both for having me. Appreciate it.